26-255, entitled Yudi, Hernandez, and Stephen Brave versus Brad Pistotnik. We have Mr. Stephen Brave for the appellant and Mr. Russell Hazelwood for the appellee. Mr. Brave, we will begin with you. And first I'll ask, do you wish to reserve any of your 15-minute time for rebuttal?
I would, Your Honor, if I could reserve 5 minutes.
That is granted, and you may proceed.
Thank you, Your Honors. As the court's aware, this case involves imposition of sanctions against me in the amount of $275,000. The initial sanction hearing was held in 2018. The ruling from Judge Woolley came out approximately 3.5 years later in 2022. The main issue raised on this appeal is the facts that the judge relied on in sanctioning me under both KSA 6211, 60-226, and the inherent power of the court. I don't believe there's any dispute from anyone that Judge Woolley conducted independent research into events that occurred after the 2018 hearing, events that occurred before the 2018 hearing that were not introduced into evidence, and based on that research, relied on it and imposed sanctions under all three, the two statutory bases, and then the common law inherent right of the court to impose sanctions for bad faith. Case law is clear that a judge is not allowed to rely on his own independent research. We had an independent, I guess you can call it investigation from Mr. Pistotnik's attorney. We had a hearing based on that. Evidence was presented. There were over 20 exhibits introduced by Mr. Pistotnik. No witnesses testified, but the evidence was provided to the court. Under Rule 2.9 of the Code of Judicial Conduct, that was all that Judge Woolley was free to rely on. If he relied on anything else, whether it be by judicial notice or independent research, he violated the law. And that
well, let me interrupt you with a question. One of the Woods v. Grove factors is it required the court to look at your conduct in other cases.
Agreed.
And these various other cases that all involved you and Pistotnik and had the same issues, they were all at least discussed at the hearing that you had on the matter. And I don't recall you making any objection to the judge listening about those other cases. So why was it improper for the judge to look at those other cases?
Two parts to that. Your Honor, I agree with you that Wood v. Grove, one of the factors is the judge can look at other instances of wrongful conduct. My argument on that is that was a part of Mr. Pistotnik's duty at the hearing. If he claimed that there was specific acts of misconduct, he could have presented those. So that wasn't done. The only way the judge can go back and then look at other judicial facts would be through judicial notice. So if we assume for the moment that if he had given me notice, hey, I'm going to go look at the 2014 dissolution between Brad and Brian, which was not discussed at the hearing. No one brought that up, but he relied on it. If he had given me an opportunity to address that, then that would comply with judicial notice. And even if he had done that, Your Honor, as you know, under, KSA 409 through 412, if you go back and you look at something, even if you do it improperly, for judicial notice to be valid, you have to look at facts that are not contested. So when we had the hearing, I didn't object to Mr. Pistotnik introducing evidence of my case against him when I left his firm, the case with Manaz Consolver, other matters that Mr. Hazelwood may have brought in. I don't remember what that was, but that was simply to show that those cases had occurred and how they had ended up. I didn't say, and I never agreed, hey, Judge, go through every case, regardless of whether it's been introduced into evidence, find contested facts that were not subject to judicial notice. The law is clear that if there's a disputed fact, that's not subject to contested notice or judicial notice. It's only
and the judge in this case, in the ruling, indicated that the sanction award was just for this case, and the judge only looked at the other cases to determine motive and a standard of conduct. And again, those cases were discussed at the hearing without objection.
Right. Again,
So I understand under 6410, I believe it is, to take judicial notice, the parties have to have an opportunity to at least respond to what the court is noticing. But it seems like you had that opportunity to respond.
I did not. There were facts that occurred after the hearing. He went through the Lanham Act case, which was litigated in 2020. I didn't have an opportunity to address those facts. And he didn't. He says that he just did it for the context. You know, he said, I'm only reviewing all these other cases, some of which I didn't have any involvement in whatsoever. The dissolution between the brothers, he says that I tried to improperly intervene. That never happened. He said that I did wrong things in the Lanham Act. That never happened. So I didn't have an opportunity to object to him going through things that hadn't even occurred yet.
Mr. Brave, sorry, go ahead.
If I just finish that response, he also plainly said that he was relying on the 2016 CB 172, where I was a defendant. He incorporated all the facts that he took from a summary judgment motion that was entirely contested and relied on those in this case and made that clear. That was never the subject of proper judicial notice. And those were all, that case was a giant mess from the beginning. Taking those into consideration also deprived me of due process. And Judge Hurst, I'm finished if you had a question.
So when I was reviewing the briefing in this, it appeared to me that the judge accepted out things that were not included in that original motion, the cases, and specifically said that those were not relied on. Is that not accurate? You're saying, which things specifically are you saying occurred after that the judge relied on?
With regard to what he relied on, evidence of the dissolution proceedings, that occurred in 2014, that case, but I had no involvement in that, and that wasn't brought up at the hearing. So I don't know where that came from.
Well, I mean, the judge looking at that case doesn't mean if you weren't involved with it, I would assume that the judge didn't have any bad findings towards you.
He did. He said that I tried to improperly intervene in it. And as I read it, he's saying I somehow delayed that case and dragged it out. I mean, that's
that one wasn't after. You're saying that was an error for the judge to rely on that one.
Correct.
Which ones were relied on that were not in the briefing?
Everything in the Lanham Act case. That's the case that when it was argued in front of Judge Woolley in 2018, the petition had been filed, the original one, but it had been dismissed and no litigation in that case had occurred at all, as I recall. After we had the 2018 hearing, that matter was allowed to proceed. Judge Woolley obviously paid very close attention to it and relied on all kinds of facts in that. So, I mean, he wrote in this case, there's about 40 pages of facts that he supposedly relied on that were not introduced at the hearing. And I understand the court saying, well, they were mentioned at the hearing. Just because something's mentioned doesn't mean I'm just saying go crazy, go through every file you can locate and do whatever you want with it. That's a blatant.
Mr. Brave, you sued Mr. Pistotnik on behalf of Yudi Hernandez, who didn't even know you were filing the lawsuit on her behalf. And Mr. Pistotnik never represented Yudi Hernandez and to this day has never even met her. Why isn't your conduct subject for sanctions?
Because Judge Dahl specifically addressed all those facts. Judge Dahl had this case before Judge Woolley. At volume 4, page 21 of the record, he addresses all those arguments. Number one, with regard to what Ms. Hernandez knew, she was in a coma when she was made a Pistotnik client. That was set forth in the petition. Everybody knew that from the beginning. On page 23 and all the way up through 26, Judge Dahl goes through that piece by piece and says, look, Miss Hernandez, being Yudi, didn't know, Pistotnik was representing her, but everybody assumed that he was, because that is who Yudi's sister saw on the ads. Myrna's the sister. That is the connection to it. Plus, under the KCPA, it specifically says if a supplier has no contact with a consumer, which Miss Hernandez was, it doesn't relieve them of responsibility. If that were the case, then every person that ran a false ad could simply run false ads nonstop, never meet with the consumer, and say, well, I had no contact with them, therefore I did nothing. And again, I mean, this also comes back to Judge Woolley's findings. Because he says that Judge Dahl was misled, he was not misled. His ruling specifically addresses all the arguments that Pistotnik made. And so therefore, the judgment's void because he violated Rule 2.9. And even
let me interrupt you again. Sorry, but in
right.
the amount of time you have in your opening argument, switch over to your argument about the fact that you never got the evidentiary hearing that you requested.
I requested 2 evidentiary hearings, Judge. One with regard to the amount of sanctions that was set for a bench trial. It was supposed to occur,
and that's what I'm referring to.
Right. And so that was going to be held in May. We had a hearing in March where Judge Wilson, who had taken the case over from Judge Woolley, just skipped that, just bypassed the trial altogether. There was no pretrial conference.
At the beginning of that hearing in March, did any of the attorneys even know that Judge Wilson was going to rule on the amount and in the case?
No, there's a scheduling order that's in the file. Can't tell you the exact place in the record, but I can look for it for rebuttal. But there was an actual scheduling order entered in the case. So, I mean, there was a pretrial that was going to occur later, I believe in April, and then a bench trial in May. And that's important because I could have come in at that point and said, look, all these things that they're complaining of dealt mostly with them refusing to comply with the order to produce things in discovery. They violated.
Right. Let me ask you 2 questions. And the ruling occurred before the discovery deadline even ended. What additional discovery did you still want to do, if any?
I filed a motion to extend the discovery deadline because it was coming up to depose Mr. Hazelwood. Because at that point, I had their billing records. I had been able to go through them and see what was related to discovery disputes connected to their failure to comply with Judge Dahl's order. One finding I don't disagree with that Judge Woolley made is that virtually all the time that was spent fighting in this case wasn't whether Ms. Hernandez was conscious when Pistotnik was hired. It was whether or not the contents of the ads were true. I always contended that should have taken 1 round of discovery. They advertised certain jury verdicts. Proving those were accurate should have been a simple matter of producing a verdict. That's public information. We fought about that for over a year.
Let me ask you, and then my final question is, the bench trial, the evidentiary bench trial that was scheduled for May that you never got, the judge just basically ruled on the fee statements that were admitted and the 2 affidavits from the lawyers who had reviewed those fee statements. My question to you is, what additional evidence would you have presented at the bench trial had you been allowed to have your bench trial?
Well, I mean, that depends on kind of what they had put on, but my key point going in there was all this stuff was not due but for anything I did. The vast majority of what they claimed expenses for was they're trying to get around Judge Dahl's order. And under the Hager case, which we relied on, it's United States Supreme Court case, all that they can get is fees directly related to misconduct. Whatever pleading I filed in violation of 6211, they have to tie that to that. whatever discovery submission I did in 226 has to be directly tied to that. Otherwise, you get into criminal sanctions.
And I'm not sure that that's answering the question, but you at least specifically objected to the hearsay affidavits of Millsap, for instance, and you said you wanted to have him testify as a witness, and
No.
the judge isn't that correct?
No, as I recall it, Millsap was actually he was present. This was done by Zoom. It wasn't.
I understand that, and you said you wanted his testimony, and the judge kind of blew that off. Isn't that correct?
Well, the Pistotnik blew it off. He didn't call Millsap as a witness. He just introduced the affidavits. The judge accepted it and said, "What do you want to do, Mr. Brave?" And that was the end of it. And then he asked, "How much money do you want?" And they said $275. He gave it to him. The journal entry makes it clear that was done to punish me, and we cite that in the Hager case. I mean, once you are sanctioning me to punish and deter others for $275,000, I get all the rights of a criminal defendant.
And when the judge asked you about what you wanted to do, you said you wanted to question Mr. Millsap, and you kept saying, "I want to stick with the scheduling order that's been provided." Isn't that correct?
No, I brought that up.
I'm trying to help you a little bit here.
No, I hear you. I brought that up at the beginning. I said, "Hey, Judge, I want to extend the deadlines," because I wanted to depose Mr. Hazelwood, and he didn't address that. And then, I mean, he just skipped over everything I said. And then he just said, "Well, what do you got?" I looked at the billing records. They're reasonable. Doesn't tie it to any misconduct. Says how much you want. And that was the trial. I mean, this wasn't anything like a bench trial. I mean, it was just a hearing where he just said, "Well, this is already decided. I've got the records now. How much do you want?" End of story.
You didn't make a due process argument, correct, counsel?
I specifically objected under Hager. Yes, I absolutely made a due process argument throughout it. I moved to recuse Judge Woolley because he had a bias. I said that was a violation of due process because he had investigated. I moved to recuse him multiple times. He first recused himself from the civil matter or the criminal matters, then the civil, or the other way around. Then at the hearing, I specifically said, "Hey, this violates Hager. I've been deprived of due process." That specific objection was made. And even if it wasn't, under State v. Smith, I mean, this is a constitutional issue. I got hit for $275,000 in sanctions. I think the court doesn't have to, but you obviously have the discretion where there's been a deprivation of rights this severe to look at it sua sponte. But you don't have to, Judge Cobble, because I did specifically object to a due process violation.
And is that actually that 275? Is that really punitive? I mean, or is that compensatory? I mean, we're looking at less than the amount of the fees.
All we have to go on, Judge, is what he put in his own journal entry. And he specifically wrote that it was partially to compensate Mr. Pistotnik and partially to punish me and partially to deter others. If he wasn't doing that, there would be no reason for that language to be in the journal entry. And when he put it in there, I think we're all required to rely on that's exactly what he meant, and that's exactly what he did. And that's in black and white.
Hearing no other questions, counsel will go ahead and turn it over to Mr. Hazelwood.
May it please the court. The district court sanctions order was sound and it should be affirmed. The record is filled with evidence that Mr. Brave has engaged in a vendetta that has resulted in an extraordinary amount of vexatious litigation against Brad Pistotnik over a period of more than 10 years. Mr. Brave has been sanctioned more than once in this case alone and has not slowed him down. There are 5 appeals so far in this case, which was dismissed on the merits more than 6 years ago. Since the first appeal, the record of on appeal in the first appeal was 15 volumes. We're now at 50. And even faced with decisions from not 1, but 2 district judges in this case, finding that his litigation activities have been outrageous and unethical, he persists. He's promised he won't stop. Last Friday, the district court or the Court of Appeals entered an opinion in I-35 auto auction versus Kevin McMaster, which I think is instructive. It mentions in that opinion 3 times that the trial judge who presides over suits is in the best position to judge the intentions of a lawyer to harass, cause unnecessary delay, or needlessly increase the cost of litigation. Mr. Brave was afforded the due process he's entitled to under the rules. This is not a criminal proceeding. Mr. Brave was not a party to civil litigation. He's a licensed lawyer appearing before a district court, which has the power to police the activities of the lawyers who appear before it. In this context, due process requires only notice and opportunity to be heard. He is not entitled to an evidentiary hearing, and consequently, it follows that the statutes governing evidence and procedure for matters between civil litigants or involving criminal defendants are not controlling. Here, Mr. Brave was allowed to brief this issue at length, to submit exhibits, to call witnesses if he wanted to, but he didn't, and to participate in at least 3 hearings before 2 district judges to address the sanctions. He has been heard. The district court found that this litigation was initiated and maintained for an improper purpose. In fact, on the record, at volume 27, page 202, lines 18 through 23, Mr. Brave acknowledged to Judge Woolley that he could be sanctioned under 211 if the court concluded that, quote, everything was done is being presented for an improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. After, and as Judge Malone noted, the evidence in this case demonstrated that this plaintiff didn't even know that she was a plaintiff. She'd never met Brad Pistotnik, never communicated with him. He didn't represent her. And in fact, she testified he'd done nothing to deceive or harm her, and she wanted nothing from him. It would be difficult to imagine stronger evidence that Mr. Brave brought this litigation for an improper ulterior purpose. Judge Woolley found, after conducting his hearing, that Brad had proven Brave's improper motives in litigating the case, that Brave had engaged in deception or lack of candor to the court and misused his attorney-client relationship by representing a client who apparently didn't realize that she was merely a vehicle for Brave to protect his own fees and pursue litigation against Brad by any means necessary. This is from Woolley's ruling at volume 11, page 161. He says Brave's actions in the case were part of multiple case motive to use the courts to obtain information, to attempt to get Brad's confidential third-party settlement documents, and to attempt to abuse Brad's deposition transcript to publicly humiliate Brad and ultimately shut down Brad's law practice. But after that, this case was assigned to a different judge who then reviewed the file and himself found that never in his long tenure on the bench had he encountered, quote, such an outrageous abuse of the litigation system and waste of limited court resources through unreasonable and vexatious multiplication of proceedings as been demonstrated here. He found that Brad Pistotnik had suffered at least $400,000 in legal fees as a result, which did not include the cost of several appeals. And in light of those unusual circumstances, awarded $275,000. And what he said is to partly compensate Pistotnik. In other words, Pistotnik had $400,000, $275,000 was merely a part of that.
Mr. Hazelwood,
Yes.
I think no one can dispute the facts of this case, as you laid them out.
Yeah.
However, doesn't Mr. Brave still get due process in this decision?
He does get due process, and he has had due process. In this case, he was allowed, he was given notice and multiple opportunities to be heard, which is the due process to be afforded in the sanctions process. He's not entitled to a jury trial. He's not even entitled to an evidentiary hearing under the law.
Let me interrupt and ask kind of more of an extended question as to whether or not he may have been entitled to it. At the end of Judge Woolley's lengthy 60-page opinion, he said, as to the amount of the sanctions, the parties can request an evidentiary hearing.
Correct.
And Mr. Brave requested that evidentiary hearing. And the court set a scheduling order that the discovery deadline would be March 31st. There would be a pretrial conference in April and a bench trial in May.
Correct.
Then on the March 23rd Zoom hearing, which I understand was just a hearing on a motion to set aside Judge Woolley's ruling. And after Judge Wilson denied that, he went right into, he awarded $275,000 in sanctions, and Mr. Brave was objecting and saying, let's stick with our scheduling order. Why isn't that problematic?
So Judge Woolley, before he dropped out of the case, set the scheduling order. If you'll look at record volume 13, page 22, you'll see that Judge Wilson sent the parties an email before this hearing indicated that he intended to take up all matters. So there was notice before this hearing that this was going to be a hearing to take up the amount of the sanction.
And that's at volume 13, page 22.
Volume 13, page 22. And I'm going to double check it right now. And yes, that's what it is. The
right,
parties are prepared to take up all issues.
But still, when they got to the hearing, Mr. Brave objected to not following the initial scheduling order. He said that he wanted Mr. Millsap to testify as a witness, and that never happened.
So at the hearing, we presented two affidavits, which were not hearsay if the Kansas evidentiary rules are applied. It is not hearsay if if the witness is there and prepared to testify. And both myself as an affiant and Mr. Millsap were there and prepared to testify. Mr. Brave, when he was allowed to put on his presentation, did not call Mr. Millsap to testify. Mr. Millsap was there for the purpose of testifying and prepared to testify, and Mr. Brave did not call him as a witness. So that's just something he didn't do.
Okay, I'm looking at this exhibit.
It says, to be clear, are you expecting to conduct an evidentiary hearing on the fee application on the 24th? We can do that, but I will need to get my witnesses lined up. This is me. And the court responded to everyone, the parties should be prepared to take up all issues.
We can do that, but I'll need to get my witness. I apologize for any confusion. I wasn't thinking that was the plan.
The court's response is at the top.
I plan to address all matters. And then there's another email from you.
The very top of page.
There's another email after that one. Right?
So
no, that's before that one. So your email that's being responded to.
They go bottom to top.
Okay, because you asked about two specific motions.
Yeah, I asked him to confirm what matters would be addressed on the 24th.
And you mentioned two specific motions.
And he said, I plan to address all matters. And then I said, to be clear, are you expecting to conduct an evidentiary hearing on the fee application on the 24th? We can do that, but I will need to get my witnesses lined up. And he said the parties should be prepared to take up all issues. All issues. Correct. So there was notice.
So
well, I'm sorry, I didn't mean to cut you off, Judge Hurst.
Go ahead.
All right, this March 23rd hearing was a Zoom hearing. And I know Mr. Brave said he wanted to question Mr. Millsap and Mr. Millsap to testify as a witness.
But when allowed,
what was there a court reporter there that could have sworn him in? How would that even have worked?
Yeah, there was a court reporter. There's a transcript of this hearing.
And there was enough notice to subpoena people between the 20th and the 23rd?
The witnesses were there. Mr. Millsap and I were there, and we said that witnesses would be there. And when I presented the affidavits, I said, we're here. And he asked Mr. Brave, do you want to take this testimony? And the transcript says, yeah, but I was really wanting discovery. And then when Mr. Brave was allowed to put on his case, he did not call any witnesses. So it wasn't that he was not deprived of the opportunity to cross-examine me or Mr. Millsap. He just didn't do it.
And those were the only two witnesses that he wanted to bring.
He didn't mention any other witnesses, so that would be.
Well, there's a requirement giving witnesses more than 3 days notice to show up for hearings.
There is nothing in the record to indicate that there was any other witness that Mr. Brave intended to call. If that was an issue, he did not preserve that. Judge Woolley did not engage in unethical or improper fact finding. If you look in the record at volume 39, page 27, lines 21 through 30, I think through page 31, Judge Woolley explains what he did. And he basically says, I looked at the pleadings that were filed in the cases and the orders by the judges in those cases. These were the cases in Sedgwick County. And I looked on Westlaw at the orders that were entered by the Court of Appeals and I looked at on Westlaw at the orders that were entered by Judge Melgren in the 10th Circuit on the Lanham Act case, which involved very similar claims by Mr. Brave personally, and which was an integral part of the discovery disputes in front of Judge Woolley and part of the prior appellate decisions in this case. They were the basis of some of the sanctions that were issued in the case before. And as Judge Malone correctly pointed out, even if Judge Woolley's findings are limited to this case, he says he wasn't punishing him for anything he did in the other cases. He was punishing him for things he did in this case, and he was looking to those cases to see if there was some evidence that there was a different motive than what it appeared to be. Judge Wilson did not go beyond this case. He did not go beyond the file in this case, and he reached the same conclusion as Judge Woolley, that Brave had engaged in vexatious litigation warranting sanctions. In this case, the district judges have the discretion over their calendar. They have discretion over the discovery schedule and the amount of discovery to be given. And they have afforded Mr. Brave due process through notice and multiple opportunities to be heard. There is no reason to have this court weigh in over the judges who were in the best position to determine Mr. Brave's intent and to set an appropriate sanction. And concerning the other issues, they did not abuse their discretion in denying Mr. Brave's motion to sanction Brad Pistotnik's counsel or hold them in contempt, and we'll stand on our briefing on that.
All right, hearing no further questions of Mr. Brave, we'll switch back to you for your rebuttal.
Thank you, Your Honor. As Judge Hurst noted, the email exchange that Mr. Hazel was referring to occurred approximately 2 days before the hearing on the motions was scheduled. There was never a pretrial conference. Even if we assumed that I was agreeing to proceed on 2 days' notice, which I wasn't, with regard to what I would have presented, the key issue that they keep harping on is Ms. Hernandez didn't know anything about Brad Pistotnik. I would have had Ms. Hernandez there to testify. She, in fact, was called to testify by Mr. Hazelwood in this case where she was subpoenaed. Judge Woolley directly questioned her. Do you understand what's going on in this case? She said yes. She told that directly to Judge Woolley's face, and he ignored all that. That's in the record as well. I mean, I've never had a client called into court to testify about a claim where she's a plaintiff and say, are you sure you understand what's going on? And she says yes. And then they say, well, this all never happened.
Mr. Brave, I'm looking at this part of the record, this email exchange. I do not see anything from you objecting to the courts saying it wants to take up all matters in the hearing.
Well, he says, I'll take up all issues. To me, issues isn't a trial. You know, to me, an issue is I'd filed motions. I wanted to extend the discovery deadline, not have the bench trial. That motion was still pending. That's one of the motions that was to be addressed.
Well, he says, are you expecting to conduct an evidentiary hearing? That's what Mr. Hazelwood asks, a very direct question. And then the judge says the party should be prepared to take up all issues.
Yeah, I never interpreted that as saying we're throwing the scheduling order out the window. I mean, if that was going to happen, I mean, I would have clearly objected. I objected to not being allowed to depose Mr. Hazelwood, which was, I was in the discovery deadline. I mean, to shorten everything. And the idea that, well, the judge that imposes sanctions is in the best position to know what happened. That makes sense. I mean, no one's disputing that, but that would have been Judge Dahl. All the discovery disputes occurred with Judge Dahl before he recused himself. He never had me sanctioned. Judge Woolley relied on what had happened on his interpretation with Judge Dahl and his own independent research. He wasn't in the best position to know what had occurred before he got the case. And Judge Wilson at the end clearly relied on Judge Woolley's ruling. There's no evidence that he went through the entire file. He relied on Judge Woolley's ruling, said, well, I was here to impose sanctions. That's what I'm doing. Case over. Under Mr. Hazelwood's argument, an attorney basically forfeits their 14th Amendment right to due process simply by being a lawyer. If you go into a lawyer and the judge doesn't like something that occurs, he doesn't have to file a motion for contempt, which Judge Woolley, if he thought that I'd done something terrible, had every opportunity to do that. He could
You have one more minute.
Thank you, Your Honor. If he'd wanted to do his own independent research, file his own affidavit, the contempt statute 20-1204A specifically allows him to do that. He never did. Instead, he relied on it, either for context or with regard to the 172 case. He incorporated all those facts by reference. That's clearly stated in the record that he did rely on those. So I was deprived due process from beginning to end of this. I would request that the court vacate the order, send it back for further proceedings, and let me defend myself. Thank you.
All right, counsel, thank you for your briefs and your arguments. This case is now deemed submitted for decision. We'll get a written opinion out to you and your clients just as soon as we possibly can. And that concludes today's hearings. Thank you.
Thank you.